Good morning, everyone, and welcome to our third presentation in our Financier webinar series. We hope you've had a good start to the year. It's the 20th of January already. Today's topic is voluntary administration and the impact on secured creditors. So in today's audience, we appreciate we have bankers, different types of financiers and lenders, and we also have people from industry. Our presenters this morning are myself. I'm based here in the Brisbane office and I'm in business restructuring and insolvency. And also in the Brisbane office is my colleague, Chris Demeyere. And joining us from Sydney is Jeff Marsden, who's an Associate Director in the Corporate Recovery, Insolvency and Turnaround team. All of us have actually had the opportunity to have a secondment in a bank, either the asset management or the credit recovery team over the year. So this topic is really quite interesting for us to be able to appreciate it, hopefully from a banker's perspective. You would have seen another smiling face on the invitation that went out. That was Nick Martin, our Melbourne partner, who's been doing a lot of presentations for us. Unfortunately, he's just not able to attend today. So what we'll cover today is an overview of the voluntary administration process. We won't go into too much of the theory, but we'll talk about it more practically so you can understand how it relates to your position and what's important for you to know. The events leading up to an appointment. More importantly, the key issues that you should be aware of when interacting with your customer, the business, its advisors, and the voluntary administrator. And underlying all of that will be the elements that are relevant to protecting the bank's position and then thinking about the risks and challenges. Okay, so voluntary administration, it's commonly abbreviated to VA, and we'll do that throughout this presentation. So setting the scene, why we thought this presentation might be interesting is sometimes voluntary administrations can come as a bit of a surprise. How do you, as a secured creditor, actually find out about them? And then how do you respond? And then what's it all about? What is this VA all about? It's actually quite common for a secured creditor to receive a call from an insolvency practitioner just telling them the company's in VA. Even worse, it's not uncommon for yourself to find out about it by the insolvency practitioner sending the notification to your PPSR team. And depending on the bank systems, it's quite understandable for that notification to take some time to get to the relevant person in the bank. And sometimes the file isn't with the credit recovery and asset management team. And we know a lot of our participants today are from that specialised section of the bank, but we also have business bankers listening in. So we hope that this presentation lets you know about that more specialised area of a situation that can happen to your customer. Of course, let's face it, we don't want our customers going into voluntary administration every day. The other issue is you might not even, so you found out about the VA, but you might not have even suspected it. You've probably all known examples where your customer's not returning calls or emails, so you actually drive by the client's premises to see what's going on. And I had one banker literally see trucks outside and all the gear being moved, and then subsequently got a call from a practitioner saying, "Hi, we're the voluntary administrator, sorry." So in business, we don't like surprises. They're nice when they involve gifts, but this isn't necessarily the surprise we want to get. So when you find out, are you on the back foot? Is this a negative? Are you concerned that, oh no, my security position's in jeopardy? Or is it almost a little bit of a relief? Okay, there's a plan now, something's going to happen. This may improve our position. So our presentation today will discuss these typical scenarios and the steps the bank and financiers can take to manage the situation in hopefully an orderly way and make informed decisions. So for all of that to happen, the most important thing is communication with the customer. And if a voluntary administrator is already appointed, you found out afterwards, then talking to that administrator. So moving on to our next slide. So why do people go into voluntary administration? What's it all about? Well, sometimes the reason they go into voluntary administration is just so quick and easy to go into voluntary administration. All you need is a piece of paper, a computer, or a pen, and the board just passes a resolution that the company is insolvent or is likely to become insolvent at some future time. Now, a lot of us, the exposure is to small and medium-sized enterprises, and the boards there can be quite small, single directors, mum and dad directors. Obviously, our larger corporate clients, there would actually be a board, and it's important that all the directors are effectively of this same view. So once they pass that resolution, they just need a practitioner to act as the administrator. And we'll talk about that being relevant because prior to going into VA, they should have spoken to someone. More importantly, have they spoken to the bank? So why have they gone into VA? It sounds like a bit of an easy solution. So, maybe they're doing it because they're running out of cash. Maybe they've got pressure from their stakeholders. Their facilities are about to expire, even a major supplier. Or it may be for more personal motivation. There's creditors putting pressure and the directors know they're exposed to a personal liability situation if they trade whilst insolvent. And there's a very common trigger, as you might be aware, the Australian Taxation Office, if a company's not paying its liabilities, they can send what we call a director's penalty notice out to the directors. And one of the solutions to get out of that personal liability is to put the company into voluntary administration. But ultimately, I think when voluntary administrations, they're called Part 5.3A, under the Corporations Act, it really is, it's like a rescue plan. It really is to restructure the company. And I think, with COVID restrictions, it's really affected some industries much more than others. And they might have been quite successful businesses, save for the impact of COVID. So we may see more voluntary administrations happening because it's a formal process to give those companies a bit of breathing space, because the VA, and we'll talk about this further, has a moratorium where creditors have to wait while you basically get back on your feet and hopefully trade out of any poor performance issues you had. So the last element there is just to recap on the slide. The objective of the voluntary administration, it's twofold. It's to maximise the chances of the company, or as much as possible of its business, continuing in existence. And if that's not possible, then it results in a better return for the company's creditors and members. So with that being the objective, I'll hand over to Jeff, because you think, how could anything possibly go wrong? Because the objective sounds quite perfect. So thank you, Jeff.
Thank you, Helen. So against that backdrop, and we thought it'd just be useful to sort of run through a couple of appointment scenarios, one being, the best possible case for the bank. VA is not an ideal scenario in any situation, but what a best case would look like against, the opposite end of the spectrum. And the reality is that if you come across a VA, you're probably going to be somewhere in the middle of the best case and worst case. But so from a best case scenario, and this is really, best case from maximising, I guess, visibility around the process and ensuring, that your security is protected and the bank's position is protected, but also the company or your borrower being able to achieve a desirable outcome through the process. So for that to occur, a best case scenario looks something like some real thought and planning going into the process before they actually appoint an administrator. So there needs to be pre-appointment engagement from the borrower and or the prospective administrator, really to get your key stakeholders on the same page with the plan that they're proposing to implement through a VA process. So, when you get that call from your borrower or the prospective administrator, as we mentioned, it may be a surprise. It could be a relief for you. You've been watching your borrower struggle for a number of months with different issues. It may be a relief for you that they're actually now thinking about this process and what they need to do to sort of correct or restructure their business to get it on a stable footing again. But a bit of planning and round table type discussions allows key stakeholders to put some issues on the table and work through them. And it's perfectly acceptable from an independence perspective for the prospective administrator to speak to, the key secured creditors and other key stakeholders in the lead up to allow the plan to be sort of worked through as well as possible before an appointment is made. Key to a successful administration is the development of a detailed plan and a forecast to support that plan. So in an administration, there's always going to be things pop up and there's going to be surprises, but if you've got a detailed plan and a bit of working around, what sort of funding is required to make an administration work and what the forecast looks like through that sort of short 5 or 6 week period that an administration runs, it allows you to sort of stress test and check that the plan actually has legs and can work to restructure the business or achieve the outcome that's desired. Important, we're focusing mostly on VA today, but it's actually important to make sure the appropriate tool or I guess appointment method is selected to implement the plan. So there's recently been some changes brought in to allow a small business restructuring process to be implemented for companies with debts less than $1 million. And for some of our sort of micro or small businesses, that is a much more cost-effective tool than the VA process. At the other end of the spectrum, if the board has formed the view that the business is no longer viable and they're unable to formulate a plan, there's little benefit in going down the VA route just due to the cost involved. And it may be more appropriate just for the business to go straight into liquidation where the assets can be sold and a return generated for creditors. As I mentioned, funding arrangements are crucial to a successful administration. You need to ensure that the administrator's got funds available to trade the business for that period of the VA, because on the other hand, an administrator is personally liable for any expenses they incur during the administration. So very reluctant to continue to trade and incur liabilities if you're uncertain around your funding or your cash flow, given it's coming back to you personally. Appointment of the administrator is important to choose someone reputable with a good track record, a good reputation, to ensure that there aren't any surprises once the appointment's made. And really, once you've sort of had these roundtable discussions, you've sort of formulated a plan in the mind of the directors and the secured creditor and the incoming administrator, you can then make the appointment and seek to implement the plan. And look, the best case scenario is the company restructures, it comes out the other end on a stable footing, the bank retains its customer as security, and creditors receive a better return than what they would in the alternative. Just move on to the next slide, please. The flip side of that, the ugly appointment, is you get no engagement from the borrower whatsoever. So you're sitting there with your first ranking security over the assets of the business. You think your borrower's been performing well, and all of a sudden you get a call or a notice through the email that your borrower has gone into voluntary administration. That makes it very, very difficult to implement a plan that will deliver a desirable outcome to all those impacted. If you're finding out after the fact, it's quite difficult for a bank to work through a process to give funding, to agree to a strategy when you're being asked to make a decision sort of on the spot after an administrator's already taken control of the business. And as I mentioned, if there's no real engagement prior to the appointment, it's difficult to know whether the funding that is probably inevitably going to be sought is enough to achieve the desired outcome, if the other stakeholders are on board, if there is any sort of planning, or if the administrator is just sort of thinking of trading on a whim in a hope that they might be able to achieve an outcome. Importantly though, the position of other key stakeholders, if they haven't engaged with the bank, they're very unlikely to have engaged with key customers or suppliers or landlords, other stakeholders in the process. And if they haven't done that, the ability for the administrator to trade and implement a plan is extremely compromised. And if you haven't had any communication sort of leading up to the appointment, it's highly likely you're going to struggle to get communication as the process goes on. And being left in the dark in terms of a customer where you're a key stakeholder is as less than ideal. And you know, if we see this play out, you know, in a worst case scenario, you get to, you know, the end of the VA process and you don't have support from key stakeholders, the business inevitably fails. You see, you know, the value of your security reduced to liquidation value, creditors receive no return, employees lose their jobs. It's you know, more often than not, if this is a sort of process that's implemented prior to appointing an administrator, it's pretty ugly at the end, and there's usually a shortfall to the majority of people involved. And so I'll pass over now back to Helen and Chris, who'll talk through some key issues.
That's good, Jeff, because that was getting too gloomy. We definitely don't want to dwell on the undesirable, but Chris will definitely be able to walk us through how to avoid that and how to salvage that situation. Thanks, Chris.
Thanks, Jeff, and thanks, Helen. We're now going to look at some of the key issues during the VA process, and we're going to go through this with 10 key questions to ask. And they started out as questions. They're a little bit more like topic areas now, but there's plenty of questions to ask the administrator and the director as well. As Jeff has explained, the best or worst case scenario could present, but we think that the very similar questions are relevant throughout the VA or even pre-appointment. The responses you receive from the administrator will definitely help you assess the quality of planning that they've undertaken and whether they can demonstrate the plan is in your best interest and you're able to make an informed decision as the bank. Overall, communication and engagement are the key. And I'll just note, being a VA, we're going to assume generally in these scenarios that the business is continuing to trade. So we're just going to pop down to slide number 1 now. Why voluntary administration? Well, I think Jeff and Helen have touched on this a little bit already, but it's always important to understand what the trigger point is for the appointment. What is the director's motivation? It could be one of many things. I think, as Helen has already touched on, it could be creditor pressure from director penalty notices. It could be concerns about personal liability from insolvent trading, or something such as the upcoming expiry of bank facilities. It all weighs on the director and can influence their decision making. The director, on the other hand, they could be generally looking to save a viable business, and the viable business just could have that isolated issue. It could come down to simply a store or a location or a business unit has had an issue, and that business unit could be non-core to the operations. Management may have been distracted from those non-core operations. They potentially a supermarket operator, and then they've decided to buy a farm or expand into another business area. That cash cow supermarket, that might be being brought down by that non-performer within the group. Your customer could have just had some bad luck. Maybe they're a builder and they've had a project go extremely wrong. Maybe it's all because of COVID. They operate a bar or a restaurant and they've just had to shut their doors, and there's a short-term issue there, but in the long term, they're operating a profitable business. There's some other factors to consider. It could be industry changes, it could be changes to regulations, or it could be the domino effect, a failure of one of the customer's debtors. Potentially there's too much concentration risk, and that failure just domino affects your customer. You may also find that the director could just have some false hope. Maybe they found out about the VA process online or from a friend, and they really think it's a good process. However, the appointment should have been a liquidation. Maybe there's no hope for a better outcome. But hopefully, as we go through the 10 questions, we can help form that view. And I'll just touch on it, but the director may have received advice from a pre-insolvency advisor, and you often question whether that's the right advice. But now that you may have been able to understand the issues and why the business has gone into voluntary administration, we can now start thinking about what the better outcome is. And that's on slide 2. So what is going to be the better outcome? And hopefully the administrator has a plan for this. That's the expectation. If the business is going into VA, it could be that the business is just like it's just skydiving, and the plan hopefully can act as a parachute. The administrators can come in, they latch on to the business just like a skydiving instructor would, and they grab that business and hopefully glide it down to a greener pasture. But although you have that instructor to help you out, you've got to make sure they got the right skill set, because the right skill set will help the business and help themselves out, develop the right plan, and that's what you need to know, understand what the outcomes are for hopefully that better outcome. So during the VA, the administrator acts as the company's agent. They take control of the business, the property, and its affairs. And hopefully this is a relief to you, and we've touched on that. There's particular circumstances where you may have lost the client's trust. There might have been years of poor performance or poor communication. So now that the entities in VA, the administrators, they get some relief. They get some breathing space. They get a chance to plan that better outcome. They get a statutory moratorium on enforcement. They have time to understand and assist and recover from the issues the companies experience. We'd expect that they can continue to trade. They may sell assets which are surplus to the core business. They can restructure or sell the business and potentially compromise debts. That's often undertaken during the DOCA process. Another thing that's important to understand is who is going to be the beneficiary of that better outcome. Ideally, it's the key stakeholders, but it could be anyone. It could be the company continuing to trade, employees having continued employment, the bank retains a customer, hopefully future revenue in years to come, and potentially in the worst case scenario, maybe the customer is exited from the bank in the best possible way. Creditors hopefully limit their losses, but you've got to be careful and make sure it's not simply a process for the director or their related entities to benefit. I think that's an important thing to understand early. I'm just going to very quickly touch on the DOCA process at this stage. The DOCA process, it's a deed of company arrangement, often abbreviated to DOCA. It outlines how the business is going to continue to trade following a VA. That's where, at the end of the VA, the creditors decide that's the future that they want. The DOCA outlines who gets paid, how much, when, and what the source of funds are. The company often continues in its restructured form, and it may release the company from some debts. So that's all I wanted to mention about DOCA at this stage, because we're going to continue on to question 3, which is trading on. So the business will likely trade on, and the administrators will likely need to retain their workforce. So part of that plan is understanding, okay, has the administrator considered whether there are going to be any issues in retaining that workforce? What's the expected reaction from employees? Some employees may need more management than others, particularly key staff in your business who are very important for the ongoing success. Will those staff buy into the plan? Will there be union involvement? A lot of businesses have highly unionized workforces, and the administrator will have to plan how they're going to manage that. Also, during the VA process, it's common for the workforce to be rationalized, so they'll need to consider the impacts of that, the costs, and whether they're able to stand out employees, whether that's something they can do under the awards and in industrial relations legislation that we do have. Key suppliers, they also represent both a risk and an opportunity. So it's a risk that those key suppliers may not be keen to continue to supply. Has the administrator engaged with them and established that continued supply? Or if there are going to be issues, how are they going to manage being held to ransom? Are they able to fund that? Are they able to negotiate their way out? Or is there an alternative supplier? Keep your options open. And it also represents an opportunity to renegotiate terms with your suppliers. It might be able to improve that business and cut down the costs, reduce that cash burn, and hopefully continue trading in a profitable way. Landlords, I'll also briefly mention. The administrator will get a 5-day rent-free period at the commencement of the VA, and where ongoing commitments are met, the landlord is unable to enforce during the VA period. I'll mention that it's important to keep the landlords on side, because their cooperation may be needed while you're continuing to trade, and also if you're potentially selling the business, you may need a lease assignment. So keep them on side. That's something the administrator needs to do. Hopefully they've got that all planned out. I'll just quickly note that a receiver and manager doesn't have those same relief mechanisms as an administrator does with the landlord, but I don't want to go too far into that today. Another couple of things that hopefully is covered in the plan is the administrator's thinking in relation to specific licensing requirements, whether it might be liquor or gaming or building licenses. Each state and territory has different rules and regulations. There may be restrictions on who can be the licensee or who is able to run that business, and the specific conditions of that license specific to insolvency. But the most important thing that you would want to understand is how the administrator is mitigating risk. And before we move on to the next slide, Helen's going to help us out with the next slide, I think. But although the existing debts aren't dealt with during the administration, there's ongoing trading costs that are still going to be net. So they're going to need a financial plan. Trading on costs money. So Helen, I think you take it from here.
Thanks, Chris. Yeah, so our next topic is funding and the financials. So you might be thinking, it sounds like I'm doing all the work here. I'm the secured creditor, I'm the financier. Why do I have to ask all these questions? Ideally, for a VA to be successful, it's all about engagement. And so Jeff did say, the undesirable scenario when you find out too late. All is not lost. With this toolkit, hopefully you can walk away with today, and a lot of this information you already know, but we thought it was great to have a refresher and maybe to put it into 10 convenient points. It's constantly engaging with the administrator, asking for this information. The administrator should provide all this information because ultimately the bank needs to make a decision about whether they're going to support. And the first port of call on the phone call to the bank is often for the funding. If you're their primary financier, and even if you have all their transactional banking, we know that's often not the case. You might be the secured creditor, but they've, for particular reasons, they might have taken their banking elsewhere. So if we talk about that, the plan sounding good, they've worked out they can trade on, how they're going to pay for it. Well, first up, it's just good to be aware of, are they your assets that they're going to rely on? So specific considerations for different secured creditors. So if you've got a general security agreement over all the assets and undertakings of the company, then all those circulating assets. Voluntary administrators, because we are personally liable, it's very prudent that we don't take an engagement unless we know there's sufficient funds there to be able to carry out the engagement. And that does, of course, include the administrator's remuneration, which can be quite significant because you effectively are taking over all the management responsibility of the company. So straight away we want to see, is there cash at bank? So something maybe to flag here, you know, one of my earlier slides, when you find out a VA, how do you react? Well, if you've got a lot of credit funds, you know, do you freeze them straight away? Do you offset those credit funds against other facilities that you have? Does that then take the working capital that the voluntary administrator needs? Where are you in the order of the secured creditors? Can you act on your assets differently? So it's good to be wary of that, because with your decision making, you're always thinking about, do I control my assets through my own appointment, or do I let the voluntary administrator use them for the desired outcome of being a better outcome for everyone? Sometimes, though, they're surplus assets or non-core business assets, and part of the voluntary administration plan could be quite simple, where they are sold. But as a secured creditor, what level will you be comfortable at releasing your bank security? So it's very likely that the voluntary administrator will ask the bank for funding. So ultimately, this is when you get all that information you may not have got in the past. You should have a well-qualified professional who's had lots of experience at doing projections and are able to give you those forecasts with the assumptions of what they're intending the cash flow to be, and what we often call the cash burn, and how much money we're going to use over time. So when you're asking these questions, you'll get a bit of a feel for the quality of the administrator's projections. If they can't answer all your questions, what are you doing about suppliers, employees, what if revenues don't meet targets? So you'd want to make sure your administrator has considered different scenarios. If it's a trading business, retail, hospitality, are we trading all outlets? Are we reducing? And have we done sensitivity analysis if trading performance doesn't reach the level that we expect? So thinking about the funding is going to be an ongoing and evolving process, because they take over immediately and they normally trade immediately, and then they're assessing how much trading they can do. So you'll want the constant update of the actual to the budgeted performance. So that moves us to, I suppose, the next key issue to talk about. So just over to slide 5. So what are the integral part to the success of a plan comes down to management. So how is the administrator going to manage the risk? So if there were issues affecting performance which caused the VA appointment, how are things going to change? How are they going to manage those risks? One of the things that have changed is, the actual people now in charge. You do have those administrators there. What we've talked about, I suppose, 3 main risks. Trading on and the operational risks that may occur. Chris has touched on some of them when you talk about employees and suppliers and licensing issues. So they need to all be addressed. Then there's the financial risk. Early on in the piece, the administrator comes to you with the projection of expected funding and how sales and collection of debtors may be able to fund trading for so far, but plans may not go as intended and additional funding will be required. The bank would need to reassess what is your level of comfort and how much funding can you give. Another trigger might come as a secured creditor. You'd have your exposure there. You would probably know you've got bank guarantees and performance guarantees that may have been given depending on the type of industry. What we sometimes find is, if there has been a very successful company in the past and therefore they've had a great banking relationship, sometimes things happen where there's not that same level of scrutiny as a new lend. And, we have seen scenarios where a sort of lease premise isn't proceeded with, but the bank guarantee just hasn't been returned. So you can find there's loose ends like that come to fore when it's in administration, or if part of the plan is going to close certain stores or not continue with certain lease premises, it can trigger, that bank guarantee, something that needs to be taken into account as your total exposure. But in thinking about that, how can you mitigate that financial risk? Part of the plan may be that if there's new equity coming in or new owners coming in, there may be assignment of leases and then replacement of bank guarantees. So completion risk, we've talked about a plan to an end. So if part of that plan involves a deed of company arrangement where funds are going to be contributed or certain assets are going to be sold, there could be issues with things not going to plan. Often there are competing interests. We've mentioned landlords. There could be other secured creditors, creditors with key pieces of machinery. So it's a process of getting all those different key stakeholders to agree to what is proposed as the plan. So you'd want to, I suppose, be dealing with the administrator where you can ask those tough questions. Well, what is the plan B? Have we considered these other scenarios? And more importantly, is the plan constantly being monitored and that regular feedback coming back to the bank? So on your forecasts and financials, we'd expect to see really timely reporting to the secured creditor. So we'll now move on to, I suppose, an example. Chris, if you'd like to run us through that.
Thanks, Helen. Yes, we just wanted to look at a very hypothetical case study at this point, and it's outlined on the slide there, but I'll walk through it. You may have come across, sorry, I'll start again. we're going to talk about a business which was a training college specialising in English and vocational courses. They had a lot of international students, but with the onset of the COVID pandemic, their enrolments just plummeted. The directors made the choice to place the company into voluntary administration, and what the voluntary administrator did was they quickly reduced the cash burn. The process allowed for the administrator to exit CBD leases, reducing the cash burn, moving classes to online. As we said, they didn't have to use the lease space, redefining what the group's offering. They had courses which were unprofitable. They negotiated with competitors and offloaded is a bad use, but moved those students into a different course with a different operator. And also they were able to reduce staff numbers. And cash burn is often quite important. It helps them manage the way through, because cash is king, and it's also quite desperate to have during the VA. But the company continued to trade during the VA, and throughout that process, a DOCA was accepted, and creditors were paid a dividend through that process, and the business continues to operate. It's just an example how a trade on through a VA may progress. It was COVID impacted. It was all about what the administrators did to reduce that cash burn. They saved the business. Business value was retained. They retained jobs, and hopefully, just like this, your customer, if they enter VA, is also a good news story. We'll just move down to the next slide now. Number 6 being the advisors. Now, we found out a lot of things. We've asked plenty of questions. You're understanding the plan, and although the administrators may not have had all the answers to your questions, hopefully what they tell you will help you understand whether the administrators and their team are the right people for the job. Part of understanding that is understanding their credentials. That's both the administrators and also their other advisors that may be involved in the process. They may be accountants, lawyers, or specific industry advisors, experts you may call them. And whether they have the skill set, whether they're reputable, and whether they have the expertise required, that's very important to making sure that the VA is successful and the better outcome is achieved. So what is their reputation? It's their integrity, it's the quality of communication throughout the engagement, how they communicate that plan, and how they operate. Every administrator operates differently. There's ones that specialize in specific industry areas, and there's ones that have got a lot of experience in bigger jobs or smaller jobs. So you may just have the wrong administrator in there. But what you really want to know is whether they're going to give you confidence, and you'll see that from the actions and their plans and their answers. Are they keeping you well informed? Do you think you're willing to support the VA? Do you feel like that the administration and the security is in good hands? Have the administrators considered the banks and your interests? And that'll help you form the decision on whether the plan's reasonable, undesirable. Maybe the plan is everything that you've heard all before from the customer and just wrapped up into some plan from the administrator. Maybe the plan has too many uncertainties. You'll understand whether you have confidence in that administration team, and that also leads you to considering whether someone else is better suited to the job, or simply they need more or different assistance to complete that job. On a later slide, we're going to talk more about you have the option to replace or enforce. However, I just want to note before we go on to the next slide, talking about your security and decisions. Because the advisors are now involved, and Helen's just briefly touched on this earlier, you may be able to obtain information from your customer that may have been withheld in months and years prior, whether that's financials or forecasts, even taxation information. And you may have concerns. You could ask the administrator to investigate something. You might be concerned that money's being drawn from the company. that might be something that is of interest to the administrator and something that they can look into and able to communicate to you. Hopefully these accountants and advisors are more reputable and are able to provide you with more objective, fair and complete representation of the financial position. But as we said, we've asked plenty of questions. You're forming an opinion on the administrator. Before we make a decision, we're just going to have a look at the impact on the bank security. And Helen, I think you're taking it from here.
Thanks, Chris. Yeah. So with all the information we've gathered to date, we're trying to determine, does the proposed voluntary administration plan, does it protect your security? Does it just, preserve it, or is it possibly going to enhance it? And I suppose that simply is, well, what's in it for me? So the information we've gathered through, I suppose, the understanding how your bank security will be impacted will be underpinned by what's the administrator going to do with your security, and are they relying on it for funding? So in the best case, the VA will, lead to an outcome where you're better off. And the potential worst case, as the guys have outlined, is if the voluntary administration plan isn't able to be completed. For example, a sale is a going concern. We're all familiar that normally retains value and improves value. But if that's not possible, worst case scenario, the company progresses into liquidation, and then your assets are sold by liquidation with a lesser value. So in considering the impact on your bank security, we've already touched on it's quite different depending on what your security is. If a P&E financier, you may take a different view on a deed of comp arrangement and the VA plan versus a secured creditor with security over everything. Similarly, someone with debtor finance. So each secured creditor needs to assess, do I need to be part of the plan, and how does the plan impact me? So hopefully, you're familiar with your customer, and we are going to talk about that as a protection strategy later on in this presentation. But sometimes these voluntary administrations can catch you unaware. So if you're not familiar fully with your security position, we recommend getting that urgent security review done. And as soon as possible, put it on the record. Let that administrator know what your security is, because it will help. Sometimes misunderstandings can arise. There have been times where a voluntary administrator goes in, they assume there's all that cash in the bank that they can rely on, but that's the way that perhaps a refinance might have been done in the past. There are different securities held between the transactional bank and the bank that holds, I suppose, security over other parts of the business. So it's best not to assume, and definitely put that administrator on notice of what your security is. So you want to be talking to this administrator, and you're probably very used to getting sort of like an estimated security position. So with the questions you're asking, you would expect the administrator can give you that information. And we'll talk about reporting and the formal side of reporting in the next few slides, but underpinning our whole presentation today is about plan and communication. So at this second meeting of creditors, that is where the creditors get to actually formally vote on the plan, and the administrator has to do a very detailed report in preparation for that meeting and give an opinion on what's the best course of action for the company. So under your formal voluntary administration process, there's those three outcomes. You return the company to the directors, the company thus goes into liquidation because it's insolvent, and there may not be a plan, or the plan can't get up, or there actually is a deed of company arrangement, a plan that's being put forward that will restructure the company in some way, and it may involve original ownership being retained, or some changes, or some aspects being sold. And as part of that assessment, the administrator has to say, well, what is the return for the creditors and all the groups of creditors? And a deed of company arrangement gives you the opportunity as an administrator to deal with different creditors differently at a different rate of return. Primarily as a secured creditor, your position should be protected. You do have priority, but there may be elements of the plan that require some sort of level of compromise or restructuring. So effectively, you should be able to get that estimated security position. That's very important for your decision making. So as part of the plan, you want the administrator to consider, well, what is the best method to, deal with your assets? Should they be realised or retained? We've already talked about standalone assets. That's the other bullet point there. Another very important factor for banks and financiers is, I suppose, the community impact, industry impact, and impact on employees. And of course, we'd know under the Corporations Act that employees are also given a priority, and that's out of those circulating assets. So as a financier in assessing, is the plan in the best interest? It's often very common for banks to be mindful of how the employees are dealt with. So that's something you'd expect the administrator to tell you. Just a little note on security. If you did have security perishable goods, then there's protections under that they can be dealt with quickly, because by their nature they will perish. So now we're moving on to Section 8. Top 10 questions. How does the bank make its decision? What's it going to do? We've got a lovely image there of the two forks in the road, two paths to take. Ultimately, a best case VA, then you'd expect the preferred outcome would be for the bank to support the administration. So what is that preferred outcome? Is it a customer that you're going to retain? Are you comfortable with the management that's going to in place, what that new customer is going to look like? Are you comfortable with any compromise you've had to do on the bank's position if certain assets are being sold at a particular valuation reserve that may be different to what you were carrying in your own internal records? But more importantly, thinking at the overall outcome of the VA and what the intention is, we're very mindful that banks do consider, the reputational sort of factors. Really, the bank's sort of involvement with the plan is often so critical because it relies on that bank support. And if the bank doesn't support the plan, it may not get up. So you perhaps would have regard to what's the industry or community aspect, especially if it's a key employer in a small regional area, or it was an industry that's gone through some significant hardship at the time. The one-off misfortune as a trigger for the VA, if it's COVID impacted. That's why we started with understanding why it went into VA, because it's quite relevant to can those issues be resolved? It's not a mismanagement issue, perhaps it may be a one-off where the VA is just the best mechanism to help the company get back to performance. So we talked about the outcome of a voluntary administration being at their second meeting of creditors, where the creditors get to vote. So just to run through for our participants who's not too familiar with the technical side of voluntary administrations, the timing's really relevant, and the Act has tried to make it quite short so that the company can move on quickly. But realistically, it often can take time to actually get a plan up, because often a plan can involve third parties becoming investors or third party acquiring certain assets. So typically they're around 25 business days after appointment, and there is an extension if the appointment falls near Christmas or Easter. But very common administrators will go to the court to get an extension of what we call that convening period. So going back to talking about the funding the bank needs, those forecasts that are being prepared need to take into account any extensions that may come up in this time frame where the administrator is trying to put the plan together. Because the deed of company arrangement plan may not come from the directors, it can come from other parties. So the bank as a creditor will get invited to that meeting and get all those notices, and they can vote. Just something to raise for those familiar with liquidations. I know banks and liquidations are quite anxious about voting because it means you're effectively giving up your security. You'd only be voting for any shortfall. That's not the case with the VA. The banks can vote. With the deed of company arrangement, anybody who votes for it is bound by it. Normally, you may sometimes find banks abstain and they make a different arrangement with the administrator, which is aligned with the deed, but it may have particular milestones. So I've just put on the slide here, when you're making the decision, the administrators come to you with the proposed plan, but there may be elements of the plan that not in the bank's best interest with regard to maybe the values in respect of securities that are being released and the return to the bank, or the timing, or some of the preferences given to other stakeholders. So as a key stakeholder, we would recommend that you negotiate those points, and the deed of company ownership may be amended. We touched on a little bit about another major decision the bank can make, and it's, I suppose, integral to the success of the plan is the right people for the job. All creditors could have that view and that assessment, and at the very first meeting that is held, and that's within the first 8 days, the main purpose of that meeting is to let people know we're in administration. They can come together, ask questions, and we capped at the beginning how easy it is to go into administration. The directors can just appoint someone. So if there is any issues with independence, because one of the roles the administrator does have to consider is investigations into the conduct of those company officers, there may be a scenario where another administrator is put up, nominated to be a replacement. In practice, we don't see a lot of secured creditors being the driving force behind that, but they may support a nomination if it's put forward by other creditors. Mainly that might be because secured creditors, financiers, depending on the type of their security, they do have that option to take a completely alternative path and enforce. So they can deal directly with their security, put in their own practitioner as a receiver and manager. It may avoid some costs, so sometimes it may be the preferred decision, but weighing up that decision will really depend on the strength of the plan, and if the bank's position can be protected through the plan, there shouldn't be a need to appoint a receiver and manager. That's on a technical point under the Act, so that an administrator can get on with the plan and, I suppose, ring fence everybody so they know that no one's going to, I suppose, pull the rug out from underneath them. The Act basically says a secured creditor, you only get this period called a decision period to make your decision if you're going to appoint your own receiver and manager, and it's just 13 business days, but it's very common and we highly recommend it for secured creditors. You can ask the administrator for a written consent allowing the secured party to enforce at any time, and we call them a 440B notice. So I'll now move on to Chris to, I suppose, we're at the tail end, we're up to our 9th topic and bringing it all together.
Almost forgot to unmute myself there, Helen. But yeah, we're up to number 9, and I was just looking at the clock, so I'm just gonna push through this one a little quickly. But hopefully the best scenario presents, and but you can't rest on your laurels. You need to stay informed during the VA, and the statutory reporting, which includes day 1 notices and the 2 reports to creditors during the administration. Generally, that's not going to be timely and detailed enough to help you make those decisions throughout the voluntary administration. Obtaining additional communication and commitments from the administrator, that's going to be integral to your decision making. So asking up front how they're going to communicate, what are they going to communicate, and that will also limit the surprises you get along the way because you're kept informed of developments, you know what's happening. You got to remember that the administrators are using your security, so you're part of the plan, you're key to their plan, so they should be open with communicating. What is desirable? Well, pre-appointment, hopefully you're briefed on the plan early on, or even pre-appointment, you understand what the key milestones are for the administration, what outcomes are expected, and you set that expectation with the administrators, what and when. It might be cash flows, budgets, actuals, and how frequent. Is that weekly? At what milestones? Is it when a business is sold? Is it when valuations are obtained? Is it the marketing campaign commencing? Is it when a draft docker is going to be prepared so it allows enough time for your legal team to have a look at that docker and make sure there aren't any clauses in there which are going to impact on your security. But remember, things change. That's why the periodic reporting is so important. I'm just going to skip through to slide 10 now, which is I guess the big picture, and we just put a little picture in there of, you might feel like you're in a thunderstorm at the start, but hopefully there's a rainbow at the end. Sometimes you just stay in that storm, but hopefully there is a bit of a rainbow, because the outcomes you want are good outcomes, and hopefully it's a good news story. Along the way, if you're kept informed, the administrator's reporting to you, the business keeps trading, hopefully there's a sale, a restructure, a doctor, and that good story. Where does it get you? Hopefully it's a good outcome with a customer retained. You limit your losses, or even mitigate any losses, but any potential losses. Employees keep their jobs, there's continuing business, and all that. That's a good for reputation for yourself, and a bit of good PR for the bank supporting a local business, or it could be a rural business or a real community. The bank keeps a customer. Helen, do you have any extra comments or thoughts before we move on to that final slide in this section?
No, you've capped it all. Thanks, Chris.
Well, we'll just move to the last slide here, which sort of sums everything up there. There's the 10 questions we had, being why voluntary administration, a better outcome, planning with trading and funding and financials and risks. Do you have the right advisors involved? What's the impact for the bank? Importantly, what decisions are you going to make along the way? What communication will you receive to make sure you can make that decision? And overall, hopefully it's a better outcome. The key thing is communication and engagement the whole way through. You've got to get that commitment from the administrator. And with all that, if there's one more click, hopefully you achieve the better outcome. Always remember that the questions that we've posed throughout these topics, it's a starting point. Further questions will flow. There will be but continued engagement and communication is the key. Helen, I'm not sure if you had any further thoughts,
No, thank you, Chris. That leads perfectly to Jeff, who's going to run us through the session of, okay, this is all about when the VA happens. You get the conversation before, the conversation after. What can you do today, tomorrow, outside of the VA scenario? So thank you, Jeff.
Thank you. And I'm going to fly through this in 3 minutes.
We're so unkind to you, giving you 3 minutes.
Sorry about that, Jeff. I'm sure people will hang around.
So I just want to take a step back now, and we've talked through the VA process and the sort of immediate steps leading up to that. But this is more looking at just your borrowers on a day-to-day basis who might not show any signs of trouble or struggle, and what you can do to protect yourself in the event that they end up in VA, sometime down the track. And really it is sort of about understanding your business, your customers at a deep level. We've put some sort of key metrics there and what you need to consider, but assets, they're your security. From a physical perspective, ideally you need to understand on an ongoing basis the condition of those key assets that make up your security, where they're located, who has control of them, periodic valuations of those assets, ensuring that they're properly insured. And I recommend, physical site inspections with your customers on a periodic basis, regardless of how they're performing. It's amazing the things you can pick up from a walk through your customers' facilities or premises. We've found business owners love to talk about themselves and their businesses, and the throwaway comments that they often make when they're comfortable in conversation gives you sort of a better understanding about where they're actually at the moment and what their concerns are. Liability is important to understand, what values are impacting on your priority and security, and what other sort of lenders or claims are potentially out there that could impact your customer down the track, and push them into a position of distress and impact on your overall liability position. The business operations, just understanding the relationship and contracts they have with key customers and suppliers and how that impacts their business. You know, customers often get excited if they get to sign a big new contract with a customer or a government body, but often haven't thought about the working capital requirements that come with that. They might be, you know, onerous payment terms that really cause a cash drain, and whilst the profit on the contract looks good on paper or at the end, they haven't necessarily factored in, you know, the 2 months worth of working capital they need to inject to make that contract work. And concentration risk, we've mentioned a couple of times, and we've seen it, you know, all too often, that customers or borrowers get into a position where they rely too heavily on one source of income, and there's a bit of a domino effect if that customer of theirs, you know, suddenly pulls that contract or goes into some position of distress themselves. The huge impact that has on your borrower and their financial viability. And just quickly, got their processes, policies, and procedures. It's sort of not necessarily anything you're going to see and come through in financials, but again, you know, just having a bit of an overview of what agreements they've entered into. Importantly, sort of their PPSR protocols. If they're, you know, if you're funding their working capital, or if you're funding their inventory or equipment, and then they're on selling that or on leasing that, what are they doing to protect your interest in that asset by, you know, registering their security interest in their in their customers, and then, you know, obviously the customer undertaking credit checks and onboarding processes for their customers and suppliers that they engage with to ensure that they're not going to find themselves in a position where they're sort of hung out to dry when their customer goes into VA or liquidation. We just move on to the next couple. Thanks. So I've just put in there some long-term strategies, and the key, again, sort of the overarching theme through this is ongoing communication, but really just taking the time to understand the customer and the industry they operate in. You know, we see regularly statutory changes and regulation changes that impact industries either positively or negatively, and it's important to understand, you know, the flow and effect to your customers. The underlying value of the business, said there, it may not necessarily sit on balance sheet. It might not be value in physical assets. There's often, you know, IP and built up goodwill and really the going concern value of the business that you're not necessarily going to see in financials or evaluation, but really understanding what drives that value, and whether that be, you know, protecting key intellectual property in the business or key man is often an issue in small to medium business, making sure that, you know, the key people in the business are locked down, or, you know, don't have an ability to sort of pick up their knowledge and sort of business now, so they're building this business and go and set up their own shop down the road. Regular communication, I think it goes without saying, and the final point there, undertaking regular periodic reviews, which I'll move to on the next slide if I could. And this is, you know, often a bank will have to do sort of annual reviews of their customers, but this isn't necessarily, you know, a suggestion around that. This is more so just, you know, whether it's informal or formal, on a more regular basis, just understanding customers. And, you know, I touched on these points as I moved through the previous couple of slides, but understanding your security, where it actually sits and its value. If there's been, you know, the customer's planning to sell or dispose of assets, or they've tried to do it without your consent, you know, these sort of regular reviews will sort of pick that up. And again, it's not necessarily just looking at financial statements or that sort of thing. It's I'd recommend that it involves, you know, site visits, regular ongoing discussions with your borrowers to pick up on these sort of issues. And one issue I sort of touched on that I want to draw out there is the, you know, this debtor concentration risk and the domino effect. So we've focused this session really on sort of your clients and your customers and what happens if they go into a position of distress and potentially VA. You know, the next step removed for you is what if one of my customers goes into administration, and what does that mean for the bank security over your customer? And you know, you see it in some big collapses. A customer might have no idea they've been paid in within terms for a number of years, and all of a sudden they're found exposed, and they've got 2 months worth of trading that they're now facing a total loss on. Do they have the cash reserves or the working capital in the business to absorb shocks like that, or are they completely up to their neck, and the loss of that customer is going to tip them over the edge? So it's important to understand sort of who your customers and borrowers are dealing with and what sort of risks they face in those. And the final point I will touch on down there is having exit strategies thought of ahead of time. I know the best way out for a bank is often debt pay down over a number of years as they service their debt and amortise. But what does a plan B look like if the customer's not able to do that? What are the potential options for you to exit down the track, whether it's getting out via a business sale, asset sales, refinance? You might never think that needs to happen, but it's important to have that plan sort of in your back pocket in the event that you do get to a point where your customer is no longer able to service their debt or is facing some difficult situations. I think I might leave it there. We've run a bit over time, so I'll leave this slide. We'll send the slides around, but just a couple of other risks and challenges there to manage.
Thank you very much for that, Jeff. I really appreciate that. I think you did bring it all together. So you've done our recap, I think, quite well. So thank you very much. I thought we'll move on now to what we've covered today. So effectively, they're all there on the slide, which you can see. VA objectives is to achieve the best outcome versus the alternative. Communication is key. Early and ongoing engagement with the administrator. Good planning and execution, understanding the management's capability, what funding will you need to provide, what will be the impact on your security, and overall an outcome that protects the bank's position. We are very conscious of time. We've had one question come through that's asked about how do you pay a dividend to creditors through a deed of company arrangement. So I'll just touch on that really briefly, but the whole point of the deed of company arrangement is to deal with all the creditors' positions and how will they be dealt with. Often there'll come a pool of funds. It may be through sale of assets, or it may be through contributions, and it often is a payment to various classes of creditors, whether it's employees or trade creditors, and it can be over time, and there can be certain milestones. So we'll definitely probably have another session on deed of company arrangements and what happens if they don't go to plan, because that can happen and there can be variations. So look, thank you so much for everybody attending and sticking with us. We hope this session was helpful. You're welcome to contact us with any queries, and also too, we're also happy to discuss, absolutely no obligation. If you ever get that phone call, or if you ever drive past a client and get some concerns that a VA is imminent or it's happened, definitely we're happy to walk through those sort of scenarios with you. You'll be sent an email with the presentation slides and an invitation to our 4th session. That topic is Financial Due Diligence, a Banker's Guide, and that'll be held in a fortnight's time on Wednesday, the 3rd of February. So on behalf of Chris, Jeff and myself, thank you very much, and we hope you have a great day. Thank you.
Thank you.
Thank you.